What's up, IP friends? Welcome to another episode of IP series with Rita. So, if you're yet to listen to my previous episode on the role of copyright in the creative industry, or like I tagged it, the Copyright 101 for creatives, please check it out. And welcome to today's episode. My name is Rita Amrichinda. If this is your first time listening to me, please like, share, favorite, subscribe on any of the platforms you're currently listening to me talk right now. It will mean a lot to me if you support me, especially as we are in the Women's Month. Yeah, I was going to do that. But basically what I talk about here is everything intellectual property, from copyright, like I did in my previous episode, to trademark, patent, industrial design, trade secret, plant variety, and geographical indication. Now, for my returning listeners, you guys already know the drill now. Thank you so much. Thank you so much. I see the likes, I see the streams and the plays and the numbers, and like, oh, I didn't know it was this loud. But yeah, thank you guys so much for, always coming back to listen to my podcast. And yeah, let's get into today's episode. So prior to today, I had already mapped out my content schedule for the week, and I was like, okay, Monday, boom, Tuesday, boom, Wednesday, boom. Why Wednesday? One, it was International Women's, and I was like, okay, I need to do something, really creative. And I had it all planned in my head, okay, newsletter, podcast, and I started my research, and I was like, okay, how do I, do the extended version? And I started writing. And because of doing that, I lost my documents, everything. And the last updated one was 2 days ago, prior to today, and I was like, fuck. So I was really upset. It got me upset and put me in a bad mood, but I'm over it right now. So here I am, recording and doing the podcast version, which is kind of like an extended version for me. So it's to celebrate feature artist or feature creative or feature story for today. I opted to do a newsletter and a podcast version to talk about AI, copyright, and what the future holds for creatives in light of the recent US Copyright Office review of the Zarya of the Dawn copyright application that was initially accepted. So that's what we're going to be talking about today. So if you've read the newsletter version, thank you. I love you and I appreciate you. Please spread the word. This is not a legal advice, but my own opinion as to the case. And as usual, I'm going to give you a Nigerian African bias. Talk a little bit about it and what we should expect going forward. So yeah, let's dig in, guys. So IP friends, like I was saying, today's case features copyright, artificial intelligence, generative artwork, or creative work, which is the most viral thing right now. So the US Copyright Office, in its letter dated 21st of February, responded to Kristina Kashtonova's letter through her lawyer, Mr. Van Lindberg, concerning her application to copyright Zarya of the Dawn, which is an 18-page comic book that was previously granted copyright, only for the Copyright Office to find out via social media publication that her book was created using an artificial intelligence tool called Mid-Journey. So in line with that letter, they acknowledged that is Van Lindberg now acknowledged that Kristina was the first author based on her contribution to the works, that's the comic text, selection, coordination, and arrangement of the work, written, and then the visual element. But in their initial application, they excluded that she had used Mid-Journey AI tech, which had no human contribution. So I'm first of all going to read to you guys what the Copyright Office had to deliberate on before delving into issues as to process of IP registration, um, what to do in the event of a dispute, um, implications of this to the creative economy. Does AI have any sentient? Is it sentient enough to be accorded IP rights? How to identify authorship in an AI listed creation as an author? So just bear with me. Today's one might be a bit long, but trust me, it's going to be worth it once I'm done. So the US copyright summary for this Zara of the Dawn application is as follows. First, they started by analyzing how she described the work. The application, which was made on the 15th of September 2022, just like a couple of months ago, did not state that Kashtonova, that's Kristina Kashtonova, the author, had used AI to create Zara of the Dawn comic book, which made the US Copyright Office to now state that her original application was incomplete and incorrect, and then they had to notify her stating, look, we're going to cancel your registration. However, we're giving you an opportunity to show cause while we should not cancel this your registration, knowing clearly well that you used an AI to create some part of the book. So Miss Kashtonova, through her lawyer, Mr. Van Lindbergh, responded to that email, to the letter that was dated 28th of October. So their response came 21st of November. So more or less like a timeline that they had to respond to, stating that Miss Kristina Kashtonova is the author of the book, while Midjourney was only acted as an assistive tool and should be protected because she, that is Miss Kashtonova now, was the creative director behind the book selection, coordination, arrangement of the text, and images. Now, the US Copyright Office has precedents that they had to rely on. So they said that based on the scope of protection for copyright under the US copyright law, which is only granted for original works expressed in tangible format or medium, they also had to rely on some, okay, like I said, some cases. So I'm going to talk about two now. The first one is First Publishing Inc. against Rural Tel Service Company, where the Supreme Court explained what original means, what the term original means: to be independently created with sufficient creativity. And in the case of Burro Girls Lithographico and Cerrone, the subject matter there was photograph. This is not a photograph but an image, but then it's within that concept if you look at the definition of what an artistic work is under the Nigerian Copyright Act. Anyways, they interpreted the works of authorship to be the creation of human authors and defined an author to be the person who owns the work, who is the originator, the maker, and also completes the work, whether it's a science or literature. And they also relied on the standards of examining and registering copyrighted work. They have what is called the Compendium of US Copyright Office Practice, and it's now in its third edition, 2011. So you can check that out to be properly guided as to what the US Copyright Office rely on when they want to grant someone copyright protection. Then secondly, they also acknowledge that the comic book text should be protected by copyright, and also the selection and arrangement of images and text should also be protected by copyright because it has evidence of human intervention, since Kashtonova has stated that in her response, the letter responding to the US letter stating they wanted to cancel her application. Now, talking about the image, that's the individual image created by Midjourney. Ms. Kashtonova in her application emphasized that Midjourney was actually used to create that image and was not persuasive enough to convince the Copyright Office that the images should be registered. So while she was focusing on, oh, I used AI to create this, she did not show them that a sub copyright can be given to an eligible work that was created. So she did not persuade them enough, and There, in their wisdom, stated that they had to take what is called the administrative notice by way of using their knowledge to evaluate an application that appears to be incomplete or um, incomplete and not having enough information. So Midjourney as an AI tech operates on top of an unaffiliated third-party communication service called Discord. Now, if you're a techie guy or you're in the tech space, I'm sure you know what Discord is, but I'm just going to read out what was defined as the Discord. So it said Discord allows users to create servers that contain servers for individual channels for text or voice communication. That is what a Discord is. And it's also used to generate images in response to the text provided by users such as Ms. Kashtonova, and AI tools such as Midjourney function in the following step. First, there has to be a selection stage where the copyrighted material, such as text or pictures, in line with the reproduction right according to a copyright owner, will be selected. However, if those data selected are random, showing that they are not original expression, they will not enjoy copyright protection. Secondly, the programming phase, and as we know, programs already enjoy copyright protection, some sort of IP protection for a source code and object codes. Next is the training stage, where you have to train the AI tools such as Midjourney to come up with selected options. So for the Midjourney, you have 4 choices that you have to select from, and it was imputed in the document that I had to read, showing, I think it was a smiling baby dinosaur. So you had 4 options to pick from, and then whichever one you feel is, represents your prompt text, you select it. But then that goes to show you that the AI does not have the choice. It still has to rely on you, the human element, to make the final decision, which is like the output. So we know that let me not say we know that, but let me just say this: AI tools rely on machine learning. They rely on machine learning, natural language, deep learning, natural language processing to be able to function. AI is basically a non-human entity that was developed to emulate human thoughts, to perform certain tasks swiftly. They are trained to do all of that, and they cannot do that without the help of these things, that their algorithms and the codes and everything. And we also know that one of the requirements for copyright, that it has to be uniquely expressed in a tangible format, and I don't think AI falls under that, or because sometimes you find out the communities where these works are being created is like on Discord now, it's like a combined work, and it's great. It cannot enjoy the economic right to earn money which a human author will enjoy, or the moral right to dictate how the work should be used in the process. So I joined a session this morning where the conversation was, can AI licenses work? And we know that licensing rights are only accrued to a copyright owner, which presently under the law is a human author. Only a human author can go into an agreement. But then there are questions as to smart contracts and blockchain and the rest of them. That's you thinking, not trying to make up things or make it a bit bigger, but then those conversations will definitely be had. So moving on to the next review. The US Copyright Office also held that the images generated by Midjourney were not original and therefore cannot enjoy copyright protection, since it doesn't register works provided or produced rather by machines or mere mechanical processes that operate randomly, automatically, without creative inputs or intervention from human author, despite the fact that Kashtonova had explained that there was a creative process that she had to apply in order to generate the images using tech. Now, kind of just as a photographer, would you say your camera is a tech instrument? It's like the, what's it called now, when the AI generated image trend was, when it went viral. I think it was last year. I mean, it's the same thing, kind of gives you an idea. So would you now say the I think it's the Lensa AI app, would you say they own the right? Because the platform has its terms of use and or terms of services, and in there it said that whatever you input into their platform, you are accorded or recognized as the initial author. So, and then there's a, what's that phrase now, worldwide license to do kilo. Oh boy, yeah. One thing again you find out is that AI can't be predicted by another user, because they have limited choices to control the image generation, even with the textual prompts, whose effort doesn't even qualify for copyright protection, as the US Copyright Office um, only registers work that contains material that have been modified by a human author with sufficient original authorship. Stressing original, it has to be original and in a fixed or tangible medium or format. Now, to conclude the whole of the review that they did, they stated that the original certificate number, registration number VAU 0014809196 was issued based on inaccurate and incomplete information, and also based on the fact that it was created from non-human authorship. So because of that, they are canceling the previous registration and replacing it with a new registration covering the original authorship, consisting of Kashtonova's contribution to the comic book, and also excluding the artwork generated by the AI. So why everyone keeps saying, oh, partial registration, no be partial registration or anything. The Copyright Office was clear. Authorship only to Kashtonova's contribution, excluding the artwork generated by AI. Now, this new registration will be limited and will be issued in class TXU, and will include a cross-reference to the new registration, and also a cross-reference cancelling the registration in the previous registration titled reason for re-registration with the following registration number VAU 0014809196, which, yeah, still the same number. So they still retain the same number, and then it wrote it's been cancelled for failure to exclude non-human authorship, but we'll still have the effective date as a cancellation registration, which is 15th of September 2022. Now, like I earlier stated, this letter or the review conclusion was dated 21st February. I was going to talk about the authority that signed it, but I was like, nah, let me not even go that way. But yeah, so let me just now delve into, like, I'll call them matter arising for me. So first off for me would be, like, if you're an IP owner, please make sure that you always disclose everything when you're applying for an IP protection within a particular region, whether it's a copyright, trademark, patent, industrial design. Be transparent, be honest in your application. Why, you may ask? It seems because of this omission from Miss Kristina Kashtonova, now this became like a big circus for the Copyright Office. I mean, would you say that Mr. Van Lindbergh got the hint that the application may be resisted by the US Copyright Office if they had disclosed that the cover page or the image was designed using an AI tech, following the Dabus case, the monkey selfie case, and other cases too that have come up within the last 5 to 10 years or 20 years plus? I mean, so what does that tell you? There's a pushback from the Copyright Office of not trying to break that balance and maintain their authority that only humans can enjoy IP protection. Now, what is copyright? Copyright basically protects literary and artistic work. It gives a copyright author and owner the right to copy their works, to distribute it, to license it, to sell, to reproduce, to adapt, so long as that work in question is originally expressed, has is also an independent creation that has sufficient creativity. So when you're now dealing with AI and copyrighted disputes, because this is kind of like an administrative dispute where the copyright owner is trying to assert their right that they should be given some sort of protection within the US territory. While looking at it from the international perspective, although I'm aware that India has a law that grants both copyrights to the author and also the AI, so they are more or less sharing authorship, they are co-authors in the work. So, but you find out that in the US, there's been a pushback. In the UK, there's a pushback. When the Doubles case came out as well, there was a pushback. When the Monkey Selfies case happened, there was a pushback. And then the recent, case now that's currently ongoing as to images as well. Another thing we need to consider is, are we going to separate eligible work from the AI program first? Because we already know that AI enjoys copyright protection. Copyright protects transformative works. Would this fall under a transformative work or a derivative work? You also need to describe each of its creative expressions. So when you're describing the AI expressive expression, how will it be described? Is it a machine, original, with sufficient effort and creativity from the machine itself? I don't know. You also need to show and prove how AI has elements of human expression. Are they made to assist, or are they made to make a user's work easier? Just like looking at it from the so let's look at it from Section 10 of our Nigerian Copyright Act, where it states the initial authorship invests in the initial person that creates the work. However, in an event where it's an employment arrangement or commissioned arrangement, so are the AIs employed or are they commissioned? Or would the principle of created in course of employment apply in this situation? You also need to identify the various intellectual property rights, such as physical rights to virtual rights to assisted intellectual property right or machine right. I mean, now we're talking virtual right in terms of Web3 and the metaverse. If we're not considering AI, are we going to be talking about machine right and assisted intellectual property right? I don't know. Applicants should also find a way to engage examiners at the IPOs. For instance, what did India do differently? We need to figure that part out, but just give me a minute, guys. So I had to do refresh my memory as to that development in India. So this happened in 2020, where the Indian Copyright Office had granted copyright protection for the painting titled Suyast on the 2nd of November 2020. Now, there were two applications made before the Indian Copyright Office. One which stated that the artificial intelligence Raghav be acknowledged as the sole author. That application was rejected anyways. While the second one listed both the person that applied. So for instance, let's say this was Kashtonova, and then the AI app, let's say for instance, Midjourney, were named as co-author, and this time the office granted them a copyright registration for Suyast. What I'm sensing from this is that if you make an application in India right now, because remember, intellectual property is territorial in nature, it's only the jurisdiction where you seek to register or protect yourself that you get to enjoy protection. And now, because this is an Indian case, what that tells you now is that if you make an application before the Indian Copyright Office listing Midjourney just as the author, you won't get it. But if you stated in collaboration with let me use myself now because you never know, in collaboration with Rita reaching that and the Midjourney app in creating the Suyast, it's going to fly. I I think there was also some kind of pushback from the Indian Copyright Office. Um, they also had made reference to what is called the stating that copyright is artificially generated work and should be eligible for protection by copyright if there's human intervention in the creation of the work and provided that the other conditions for protections are met, which is originally expressed in a tangible format. AI generated work should not be protected by copyright without human intervention. That is what the International Association for the Protection of Intellectual Property had stated when that publication went viral. So, what am I trying to say? The digital artists in the US should engage the Copyright Office, the US Copyright Office, come to a compromise, set out regulations, a strict standard for being registered as an author. You can't get a sole author, and I don't think that's. I think, like I stated, non-disclosure by Kashtonova is what brought us here. If she had stated in collaboration with, but she omitted that, only went on social media to say, oh, I've gotten a copyright registration for my AI generated artwork, I think I got people a bit excited. People are really excited for that. But yeah, let's move on to our conversation. So I also stated that collaborative work in embracing the interplay of tech and IP and how it impacts the creative industry and creative works in the era of user-generated content, which requires some sort of customization, prompt, text, etc., etc. Using the employee scenario again now, would you say AI, who is considered to be the servant, wants to also be a master? Is this what AI wants? Does AI really wants to be a master? Like, I'm the Don, the Emperor, the Conqueror. Is that what AI wants? Can AI think for itself and say, master, I want to be recognized as an author? If it can, please, you guys should let us know. It's like we're missing all the fun things in the AI space, and I would like to be part of it as well. Now the development of the creative economy in the digital era, and also as we're transitioning from the fourth to the fifth industrial era, calls for some retrospect. We need to, because now you're seeing that a lot of companies are not just creating AI assistant tools for reasons best known to them, but because they want to make our lives easier. You still find out that even the AI being created still relies on human intellect. They cannot, be in charge of whatever is happening. The active automated words, AI tools really cannot exist without human input. But the same humans wish to transfer authorship or share authorship with this assisted. So I think what I might do is to put up a poll in this podcast. If you're a digital artist, are you ready and willing to share or transfer, assign, or assign your authorship with any assistant or assisted tools out there, or any AI tools out there? If yes, please, or you are putting yes, write your reason, or when I post this, write a comment. I would really want to hear from you guys, because one thing again that I come across is that most artists don't really care about the legal aspect of their creativity. So they more or less just want to focus on creating things without actually, going through the law. Would there be like a fair use or fair dealing principle as to assisted work or generative work? All of that needs to be taken into consideration. But yeah, let me know what you guys think. But let's still continue the conversation anyways. Now, according to an article by Ash Hurst, I don't know if I pronounced the law firm's name well, but it stated that human authorship is a key premise in the Copyright Act. And this now presents a challenge to the copyright protection over AI created works, and therefore the final result of an AI content can't be attributed, as it is imperative that it requires human participation to be taken seriously. So I do agree with this comment, which is why I put it down and I wanted us to talk about it. What is the foundation of AI authorship? Is it the already protected copyrighted data and texts? What exactly it is? What is it? We need to really know. Then you need to also consider an IP dispute or infringement, which usually stems from the performance of an exclusive right granted to an intellectual property owner who uses human intellect and not a bunch of programming or code in order to come up with an artificial bespoke product borrowed from existing copyrighted work. And copyright disputes are usually resolved either via litigation, ADR, that is alternative dispute resolution mechanisms such as mediation, arbitration, or online dispute resolution mechanism now, especially in light. I mean, COVID showed us that you can't be everywhere, but you can work or do a lot of things virtually. Small claims court, depending on the jurisdiction, there's always a fixed amount for small claims court. I know the US has a small claims copyright, a copyright small claims court rather. Why AI dispute would emanate from, I don't know, it could be seen to be novel if it's been accommodated by the courts. We need precedents on how the creatives or the creative industry should embrace AI related dispute or AI created works. Generally, all hands needs to just be on deck to have a well-rounded dispute resolution policy around AI dispute or AI generated work. Rules, regulation, also while embracing alternative dispute resolution mechanism. I think for now, let's do more of court sittings like litigation so that we have precedents that we can rely on. But then there are reasons why one will want to opt for either litigation or ADR. ADR basically helps decongest the dockets of the courts. It saves time. It saves time. And now we're having, I think there's like a metaverse trial case that I came about, metaverse trial hearing. And one of major disputes that may arise would be right to be identified as an author. That is, we're talking about AI related dispute now, which is like the prevailing issue right now. Considering the definition of authorship and ownership to unauthorized use of the commercial exploitation options such as licensing, royalty, and as a result of that, the creative industry is facing a radical new change. So we need to embrace all of this. We need more studies, more white papers, more conversation. So the UK, that was in 2021, I think. Yeah, but I just put on like a brief review of the UK consultation rather on AI and IP with a focus on computer generated works. Now, instead, this threshold of protecting a computer generated work shows that the court at the moment there is no harm, and currently the computer generated works enjoy 50 years protection under the UK Copyright Act, and so no need to change the law, but maybe consider it in the future since it's still in its early stage. So another angle would be AI generated work considered to be computer generated work. I mean, we really need to have to find a way to get around this, be able to come up with like a viable solution for that community. Then talking about liability for infringements, who do you hold? The programmer who used human intellect to build the AI machine, or the prompt text that was imputed into the AI tool? Would the infringement be physical infringement rights, or virtual infringement rights, or machine infringement rights? I mean, you need to also consider some some ways to incentivize the AI tools or the programmers who created this AI works. And also from this case, I kind of feel like it might be hard to tell if the liability should be transferred to the programmer. Can it be proved that he or she had access to infringing works, since this is not your typical infringement case up for review, but rather issue as to authorship without human intervention. So and that means that the scope of dispute is expanding if you are considering giving AI generated work some sort of authorship, or being acknowledged as the owner of an AI generated work. Then I'd like to thank my partner, Mr. Ishola Agbola. I'd like to thank Ishola Agbola for being helpful. I had to bounce ideas around with him when I told him what I was going to write on, and it gave me a different perspective, and I was like, cool. So he's more into the medical law, health law, and a core litigator. I'm not a core litigator, but yeah, gave me insight from a litigator's mindset, where they'll be coming from. So I'm not saying I'm bouncing off of his idea or plagiarizing him, but I have his consent to allude to certain things we discussed in terms of standards for affording IP protection and enforcement for AI generated works, the implication of using AI in the creative industry. Is AI sentient enough to be accorded intellectual property rights from the work for hire principle by considering or describing the outputs, whether it's an individual work, can it be transferred, is there a need to regulate the creation, use and exploitation of creative labor, what is intellectual property rights and intellectual property law. This is basically like the legal framework. What do they need to protect? Are they protecting original human intellect expressed in a tangible format, or the visual appearance of the outputs, or is it going to be linked to a source? Is it new, novel, and not obvious to a skilled person? Is it free for all to use? Is within the scope of development in an area? Is there a public utility value or a private right granted to the author of the intellectual property which can be protected under the law, or does the AI fall within the category of being a human and able to enjoy the private exclusive right? So thank you once again, Spice. Okay, not pushing it, but yeah, how do we get to identify authorship when an artificial intelligence is listed as the creator? Generally, first of all, IP mechanisms such as copyright regulate original expression. I think I've been repeating that throughout this conversation. That copyrights are original expressions in a fixed or tangible format that has human intellect attached to its creativity. Whereas in the case of the AI, the final output are based on the text prompts or data imputed, collected with the intervention of human. And so the question will now be, is the final output of the AI tool, such as the Midjourney, sufficiently independent and original in line with the copyright law, be it in the US or in Nigeria? I'm a Nigerian intellectual property lawyer. I have interest in IP related cases, which is why I try to review not just Nigerian cases, but African cases or foreign cases, US, UK, the rest, but give it like an African bias. So what I'm saying is, would this be enough? All of these things I've said, will it be enough now to assign the title of an author to an intelligent machine who has no personality? It doesn't even have the ability to create autonomously, even at the same time with, or the same level with humans who are able to make decisions at the snap of their fingers, like sharp. Okay, I need to make a decision. The AI is basically going to be waiting for a prompt test, like, okay, do this, and it's like takes its time, and it does whatever it needs to do. So we're going to look in depth into the role of the software developer in the journey to identifying AI as an author. I hope you guys are enjoying my conversation. If you are, please Like, send, subscribe, favorite, share. I don't know, guys. Just talk about it, please. Because I'm a bit nervous about this episode. I don't even know why. So the genesis is that softwares are considered to be original work of authorship. They are considered to be eligible work that can be copyrighted, be the object code and the subject code. Those are elements of copyright. Now, what that software does depend on the kind of IP to enjoy. Does it serve as a literary artistic work, or is it solving a problem in the society? So a copyright or a patent will work. But for the purpose of our conversation, I'm going to focus on just copyright though, which, like I said, focus on that. Now the codes itself, the data imputed into the AI tools are done for the purpose of coming up with or generating an image or music or whatever it is, and this is created by the programmer who creates it. So their role basically is clear from the get-go that they could be an employee or a commissioned project. So is this an employed project or a commissioned project? I think let's stick with commissioned project. So this AI has been commissioned to generate this work. So does that mean the AI initially, according to our copyright law, is the author? I mean, it's a bit complicated because I thought about it today when I was having that conversation on the Twitter. So I was like, the law provides the initial person, but who is indeed the initial person? Is it the programmer who imputed the codes and the text prompts, or the AI who generated the final output? So which of them are you going to grant originality or authorship to? Is it from the phase 1 or phase 4, which is the output? For instance, in 2016, a Japanese AI program created a novel called A Day a Computer Writes a Novel, and participated in a literary competition and made it through the first round without the knowledge of the judges. So you see there again that there was no disclosure stating this was created by an AI. So would you say they lied? Did they lie? Is an omission a lie? But in our case, when it was applied, that is when the Zarya of the Dawn was applied for and to be deposited, the copyright granted its copyright because they had thought that the arrangement of the work, visual elements, and images were products of human authorship. Whereas Kashtonova and her lawyer did not disclose that they had used AI to create any part of the 18-page comic book, inclusive of the cover. So now, this now prevents or presents software which falls under the scope of protection, and our original intellectual expressions gives the software developer some sort of leverage. Whereas the central goal of an AI will include reasoning, planning, learning, natural language processing, its ability to move, manipulate objects, and now create. Can the software developer claim ownership to the output of the AI tools such as Midjourney? I think that's where most of the digital artists should be focusing on. Can I claim ownership of the output from platforms or AI tools like Midjourney? If you can't, if you cannot, so all right. So according to Ross Pell, he said identifying AI will require recognizing AI as an author and inventor under the US intellectual property law. He also said that the real history of AI began with the fight against the Nazi German in May of 1940. And I was like, why May? I mean, maybe probably Taurus, but then the real history, like I said, it began within the fight against the Nazi, when electronic computer, which was designed and built by Alan Turing, had successfully cracked encrypted messages being sent by Nazi command to its naval fleet. Now, this development was clear to expand industrial revolution. So, what is the goal now for having AI or intelligent machines go beyond its original instruction to now create works other than being doing what I listed previously, to now be acknowledged as an IP author and also being a master of his own. You get my point? So these are the issues that I think we need to consider as well. So as an IP practitioner with interest in the creative space, or a digital artist, or an enthusiast, AI enthusiast, or an AI platform, what is the relevance of this case beyond the US Copyright Office, beyond the US shows? For me, basically, I would say first, this is a good precedent for us to study. So there needs to be, we need to have our own sandboxes. We need to do our research and come up with laws and policies or regulations that solve issues within our territory. Now, I also came across a publication by Kristina Kashtonova on LinkedIn. So how I stumbled on her post was, one of my LinkedIn connection had made a comment on her post, and I was like, ooh, I need to see this. So I checked it out, and she was like, okay, she's going to do another application and deposit another AI assisted comic book where she will use her photograph to train a model on her likeness. It will use the Control Alt to direct the model so that it can use her sketches, art and photograph that she took as reference, with the goal to educate. And I was like, I don't think educate is the right word. I mean, more or less like engage the US Copyright Office that AI can be used in a creative way and its results are not random and can enjoy copyright protection. And I'm like, so at the top of my head, you already acknowledge that the AI tool will be using already existing copyrighted work. Now the question will be, is the output going to be considered a transformative work or a derivative work, especially within your jurisdiction? And I think that's something that those in the art world, art. Yeah, in the art world or in the creative industry needs to consider first. If you're using already existing copyrighted work, do you not need to get no, you don't need to get a license, because you already have the right to reproduce, to share, to distribute, to adapt, to translate. You're exercising your bundle of rights. But coming to say that the results aren't random and they can enjoy copyright protection, so you get as a big show. And like I said in my introduction, this case might end up being a precedent for either assigning AIs to be an author, in line with the International Women's Day theme, which is DG Innovation and Tech, that is gender equality. I think this case, for me, accelerates women empowerment and encourages more female creatives to embrace AI assisted tools like Midjourney to push the boundaries, engage the regulators, engage and collaborate and partner. We're not on the defensive right now. Yeah, you get my point. So creatives in Nigeria should learn to engage IPUs and show how emerging tech and frontiers are viable tools. They need to also be transparent in their description. Like I earlier stated, check out the Suyas Indian case talked about, where they had to mention both the creator and AI as co-authors. African countries should consider amending their laws to accommodate and expand the scope of registration to protect the whole work or not individual parts. We need to also build research and development facilities strictly to create sandboxes that can regulate future emerging disruption, user-generated content and other content covered by copyright and registration. We also need to create regulations for resolving AI-generated disputes produced by generative tools. We also need to consider creating a balance between humans and AI-generated input, since law is very important to the art community. Another thing that I would say the digital arts community can consider is opting for a Creative Commons license, which gives them little control and they're able to share their work for free. So if your goal is not to make money from your AI generated work, I think this might work for you, because there was this question that came up during the Twitter space: can AI license their work to generate revenue like a human author would do? Presently, no, because our laws do not protect AI as an artist. Only humans are acknowledged as an artist. AI could also, another thing to consider is whether the AI works are contrary to public policy and morality. That will also depend on the jurisdiction in question. So we are coming to the end though. I've tried my best. If you feel I did not explain enough, I'm always open to criticisms, which will now fall under fair dealing or fair use for me, or you can criticize my work. You get, but here are my recommendation. We may need to create new forms of intellectual property rights, more R&D development on virtual rights, research and development on virtual rights in the wake of the fifth industrial revolution and other transformative tech. We need to create a standard for regulating and registering copyrighted work. We should depend on the jurisdiction, as the one size fits all principle won't work. We also need to expand the definition of originality with a pre-qualification requirement, considering either shorter term of protection for the AI generated work and the role of AI from the creative and the legal perspective. Consider the incentive aspect, physical right, virtual right, any other thing you can think of. But yeah, this is where my review ends for me. Oh yeah, I was gonna talk about this. Oh my god, I don't know how I forgot it. But yeah, I was thinking about AI copyright and data protection. How the fusion would be a blast, where the output cannot be transferred from one jurisdiction to another, dealing with cross-border related issues, where a creative is in another jurisdiction and using an AI assisted tools specifically created for a particular region, and then bypassing all the internet brouhaha. So data protection in terms of preserving the data that will be imputed into the AI tools. What are the privacy policies on the platforms? What are the cookie policies? What are the licensing policies available? IP policies, dispute resolution policies. Those are the things that I think we need to consider going forward. But yeah, thank you, and I'm done. I'm done, guys. Okay, so we have come to the end of episode 92. I'm counting down until my 100 episodes. I don't know what to do for my 100 episode, but if you have suggestions on how I can celebrate my first 100 episode, please send me an email to ipseriesInfo@gmail.com or tweet at me at ipseries1 or ipseries_with-reader. But yeah, thank you guys for, as always, listening to me talk about intellectual property. I hope today's episode was insightful. It was really insightful for me, and I won't say I was stressed, but I was a bit nervous while doing this research, because I was like, I'm not an expert on AI, but I'm going to put out my thoughts. And once again, thank you, Shola Agbola, for always coming through as usual. But yeah, for my IP friends, I love you guys, and see you in episode 93. Bye.